And the final agenda item is Fish and Game. Beginning with Brian, I guess.
Yeah, I have the first memo in memo number order. It's 2215. And we do have people in the audience.
Yeah, I noticed that.
Interested agencies. And so I expect at some point they're going to want to comment or amplify the comments that they've already made. This memo opens phase 2 of our analysis of public comment on the Fish and Game Code tentative recommendation that we distributed back in 2018. We distributed that, and then because of its size and complexity, we agreed to extend the public comment deadline. We also agreed to bifurcate analysis of the comments between what we've called phase 1 and phase 2. Phase 1 is comments in response to notes, commission notes in the tentative recommendation that are focused exclusively on possible reforms that could be made at the language level rather than at the organizational level. And so the idea is that those changes could be effectuated in existing law without touching organization at all. That's phase 1. Phase 2 was going to be discussion of the possibility of improving the organization of the Fish and Game Code. Both of those phases, the public comment deadline got extended, I think, a second time because of COVID. And so we're finally rolling around to the public comment on phase 2. We've been working on phase 1 all of last calendar year. We'll continue working on it this year. The remaining memos on the agenda for this meeting have to do with phase 1. Right. So phase 2 is the discussion of the extent to which we should or should not make changes to the organization of Fish and Game Code. And we received a letter from the director of the Department of Fish and Wildlife, Charlton Bonham. We actually got that several months ago, and I recommended that we hold it until the public comment deadline had passed so that we could consider it in the context of any other input we got. We did get a little more input. We got a letter from a gentleman named Mark Hennelly representing a group called California Waterfowl. And that's the totality of it. So not a lot of response to our request for comment on whether we should reorganize fish and game law. The letter from the Department of Fish and Wildlife is presented and discussed sort of cursorily. I briefly summarized the main points that the Director Bonham made and offered some background and some sort of thoughts in reaction to the issues that he raises. I think it's fair to say that the letter from California Waterfowl was mostly just an endorsement of sort of the general position of the department. And I would summarize that general position as concerned, if not opposed, to the idea of at least enacting the tentative recommendation, which would create an entirely new reorganized code. But I suspect, well, I don't want to go beyond that. They were responding to the tentative recommendation. They had some concerns. They thought, I think the concern that has the most sort of tangible bite for this body is the concern that the result of enactment of this reorganization would be counterproductive, that they think it would make the law confusing and harder to use. They also raised some process concerns about the scope of the commission's authority and whether or not we stuck to our guns in terms of taking a sort of pragmatic prudential approach to deciding what should be in or out of the proposal. But I think the main substantive point is their concern that reorganization would do more harm than good. And we can, after I'm done sort of setting the stage, you could invite them to comment if they want to add to those concerns or clarify or amplify or whatever. My bottom line take in the memo is that it would be problematic to try to proceed with a recodification of the entire code in the face of opposition from the agency that's charged with implementing and effectuating that code. If they maintain that it would be counterproductive, that it would make their jobs harder rather than easier, that's going to have a lot of persuasive effect, I think, in the legislature's deliberations. And I think it's especially the case if you try to move a bill of this size, a 1,200-page bill, plus however many pages we would have to have for the conforming revisions to the Fish and Game Code. That's going to put an enormous burden on the committees that have to analyze it. And so I think it's going to, in real terms, they're going to have to rely on sort of trust. They're going to have to trust the commission's carefulness and judgment, or they're going to trust the department's assessment of their own practical realities and the effect of this change in the law. And when if the two authorities that they would like to trust are in opposition, arguing entirely different points, I think it's going to be really hard for them to know how to proceed, and it just is not practical to ask them to do a line-by-line comparison of the proposed new code against the existing code. And that's the legislature. The other thing is that because in this instance, the affected entity is an executive branch agency, which we've never faced before in doing our prior recodification work, even if the legislature were inclined to see this as beneficial and pass it, the governor would also have to sign it. And the process by which the governor considers input from affected agencies and makes a decision about whether to sign or veto legislation is an opaque one. And it's one that we typically don't play any part in. So it would be a real roll of the dice even if we squeaked out of the legislature, we would just have, I think, a very high chance that the executive officers at the department could convince the governor that this was a bad idea, and that we'd wind up having, as I say in the memo, spent a lot of resources, burned a lot of goodwill, and not really gotten anything for it. I can tell you personally, it's a big disappointment, and for the purposes of the agency, it's a shame to have spent 6 years on this and perhaps not have anything to show for it. So I spent some time thinking about whether there is a non-binary position that we could take besides just the options of full steam ahead versus put it on the shelf and forget it. And the alternative that I came up with was to look at the possibility of doing a series of smaller incremental reorganizations in place. Not repeal an entire code, stand up an entire code, but cherry pick out parts of the code and work on improving them and make those improvements in the existing structure of the code. That's necessarily going to mean sort of foregoing some possibilities, because we'd be operating within an existing structure, which will be a major constraint on sort of the flexibility that we have. But I think that there is a possibility that a series of smaller proposals in place might be successful. And I think that because, for one thing, a smaller proposal, it's going to be easier to get everybody involved, fully engaged in evaluating like the details of the proposal, including legislative staff and the governor's office, who would have something that they could more meaningfully evaluate on their own, rather than having to entirely sort of trust the sources about whether it's a good or bad product. I also think one of the legitimate concerns that's raised about any reorganization is the transitional cost. You know, when you shuffle section numbers, people are going to have to learn new information. They're going to have to revise documents. They're going to have to use disposition table when they're researching case law, et cetera, and that's unavoidable. It's probably easier to deal with that kind of unavoidable transitional cost if you get it in smaller doses spread out over time, rather than having a huge mass of it dumped on you all at once. So I think there are a number of reasons why it might be feasible to do these smaller in-place reorganizations successfully. And I've given an example in the memo. And there's this existing Division 2 in the Fish and Game Code, which is by its terms, it's titled Department of Fish and Wildlife. And you would expect it to be a fairly standard body of law relating to the entity as an entity. What are its powers? Who is its director? What can it contract? Can it issue subpoenas? All those kinds of things. And that's pretty standard in organic statutes for executive branch agencies, is that you have at near the beginning a body of law that talks about the general organization, structure, staffing, etc., rather than program responsibilities, right? In this instance, that division starts out that way, and then it just veers off into program responsibilities. And there's like, I don't know how many, I didn't count them, 20 different chapters that are just everything under the sun. And so you've got this division that really doesn't have an organizing principle. And as I said, that makes it hard to use. It makes it hard to maintain. And so there would be advantages in cleaning up its organization. And I mentioned in the memo that, if we were to try that, there are different degrees of ambition that we could choose. One would be just to erect this heading, to divide the existing Division 2 from everything else. And all the following chapters would just be a miscellaneous programs division. Not great, but better than what's there now. I think an intermediate position would be to take each chapter and move it intact as a unit to somewhere else in the code where it belongs, so that the chapter on trout would go where the provisions on trout are, or at least where the provisions on fish are, as an example. And then the most ambitious would be to do that, move the chapters, but also, where helpful, maybe do some internal reorganization of the chapter as well, adding article headings, breaking up long sections, that kind of stuff. This would entail section renumbering, and so there would be transitional costs, but the scale would be so much smaller that it might be workable. And as I say in the memo, we could do that as a sort of a pilot project. It wouldn't be that hard to prepare a reorganization of Division 2 and have it be its own tentative recommendation and see what kind of response we get, and try the legislature's appetite for that kind of a smaller reorganization and the governor's appetite for it. And then we would know whether this concept of incremental, smaller reorganization in place is viable. It may not be. It may be that the opposition to changing the numbers in any way is strong enough to prevail, but we wouldn't know that unless we tried. So that's where I landed. Is I think that it's maybe worth giving that a shot and seeing if. The other thing is, I think it would help us to actually derive some benefit from the 6 years of work we did on proposing a reorganization of the code, because if I were to sit down and look at all those chapters in Division 2 and think about where they belong, I could look at our tentative recommendation and say, well, where did I put it here? And so I think that's, or how did I break up this very long section? Maybe I can do it exactly the same way that we already did in the tentative recommendation, etc. So I don't have much more to say at this point in terms of laying out the issues. I think you should give an opportunity for the people in the audience to speak if they want to. And at the end of the day, if the commission decides that it likes the general concept of this incremental approach, it would be helpful for you to decide also whether to move pieces as intact units or whether to permit the staff to do a little tinkering inside the box as well. So that, unless commissioners have questions for me about what I've said, I see a hand up already.
Yeah, I saw that. Angela Donlan, should we?
Yeah, I will enable her.
Well, let me see first if there's other commissioners who want to weigh in on this at the moment. Seeing none, go ahead.
Hi, thank you. This is Angela Donlan. I'm a senior staff counsel in the department's legal office. And also on today are Wendy Bogdan, our general counsel, and Julie Oltman from our legislative office. And I'm sure they'll interrupt me here periodically. But I've kind of been the attorney for the past 10 years that I've been working on the nuts and bolts of this. And so I know that I appreciate all of the commissioners being on. I know that some of you have been working on this for almost the same amount of time that I have, and then others of you are new to this. And so just for the sake of those that are new to this, I always think it's interesting to call this phase 1 and phase 2. Right now, I kind of think of it more as phase 10 or phase 50 or something like that, because the commission has done a lot of work on this Fish and Game Code study before this 1,300-page recommendation that came out in 2018. There have been a couple of bills that the commission has already proposed and that have become law. There have been a couple of studies on the department's funding and mandates that have been incredibly useful in our service-based budgeting process that we've gone through, that have been trying to align our funding and mandates. So there's been just a ton of work, great work that the commission has done on the behalf of the department that have resulted in real changes that we have used and are continuing to use. The 1,300-page study that came out in 2018 was segmented, in the first part of it that we're working on right now, had to do with about 500 sections of the existing code. And I think we have, 4,000 plus sections of the existing code. So, just a small part of it where the commission staff had asked specific questions of us and others about our input on their proposed changes. And so that's what we're working on right now, those changes in place. And assuming that, we've worked on it since 2018, my guess is that we have a couple more years to work on it. And that will result in the biggest change, the most significant change to the Fish and Game Code since like 1953. It will be a huge revision to the code, that bill. And then after that, we will need to implement all of the changes to Title 14, our regulations. And just to give you an idea of the scope of that, one of the previous bills in 2016 that the commission sponsored and proposed was, I think, changes to 17 Fish and Game Code sections that related primarily to the Fish and Game Commission. Changing those 17 sections of the code then required amending 2,000 different sections of Title 14. So that just hopefully gives you an idea of the scope of the current effort that we're working on, which is these changes in place. So it's a big effort. It will go on for some time and it will have significant results for the department. And so I I really hate to look at this in any way as 6 years wasted, because it certainly is not. It will result in real tangible changes for us and for the code. And we appreciate that work. The reorganization is something that the commission has put in so much time on. And even if we did not proceed with the commission taking that reorg to the legislature, I don't think in any way that that would be wasted work. I think what we're asking is that that could be a resource for future legislative changes that either the department is proceeding with or outside entities are sponsoring, that it would be sort of a resource that we use going forward for all of the legislative changes to the Fish and Game Code that come up, but in a more isolated kind of topic centric approach. I think that, you know, we appreciate very much the ideas in the most recent memo that Brian put out, and we'd like a little bit of time to think about those and maybe talk to Brian about what it and Steve about kind of exactly what you have in mind when it comes to reorganizing, for example, just Division 2. I think for the moment, we really feel like going forward, we would, any sort of reorganization would be best done with the, you know, the department taking the lead and using the commission's work as a resource in doing that. But we don't want to dismiss that idea. We want to hear a little bit more and talk a little bit more with commission staff just about kind of what they have in mind. So anyway, that's, we're all available to answer any questions you might have, but thank you very much.
So just to make sure I'm clear, Ms. Donlan, you would suggest that at the moment we not decide to move forward with Brian's, his sort of, for example, suggestion about looking at how one might reorganize Division 2, that we should not make a decision to try to move forward on that until you've had a chance to talk with him sort of offline about this, or what am I?
Yes, yeah, I think that's accurate. I think we would like to talk a little bit more just about what that would look like. You know, we, like I said, just looking at very isolated sections of the code and changes that have been made to the code, the revisions that are necessary to Title 14 and that kind of thing are so extensive that even really limited changes bring up significant concerns about the ongoing enforceability of the code and the ability, you know, of the users out there to understand where sections that they have been familiar with for years and years have gone. And so, yeah, I think we would like some more time to talk about it. We want to make sure and give it due consideration.
So, I mean, if other commissioners want to weigh in, they're more than welcome. I guess I'm still trying to understand. Is the big concern the sort of staff work, if you will, from the department side about revising the implementing regulations? That's the primary concern about doing a code reorganization?
No, I don't think that's the primary consideration. I think the primary consideration is that there have already been, you know, unintended consequences of the proposals that are in just the batch of 500 that we're looking at now. And those are things that we're trying to address on. Well, I mean, I can get really specific just about, you know, we're moving a definition causes it to apply to, maybe not just commercial fishermen, but to all fishermen, where, taking out a reference to, a section, I am trying to remember, there's something about, moving a reference to whether possession of a certain kind of fish is only prohibited in a specific location, or whether it's prohibited in all locations. I mean, there's just so much devil in the detail of this that even it takes our legal office and a team full of specialists looking at these to understand what happens when you move one word or one comma. So really the primary consideration is the unintended consequences of all of the changes to the code to both the users and our law enforcement officers.
So it's a question of whether this sort of reorganization would being inadvertently substantive as opposed to non-substantive. I mean, is that what you're?
Yes, thank you for saying that much better than I have. That is exactly it.
So that would be something that you would need to spend a lot of time reviewing to make sure that the proposed changes were non-substantive as opposed to inadvertently substantive. I mean, is that?
Yes, I mean, we already do spend quite a bit of time dealing with exactly that potential. And just in glancing at the rest of the reorg, there are, and so the rest of the reorg are issues that the commission has not highlighted for us to look at. So just looking at the rest of that reorganization where the commission has not sort of pointed out things that we need to talk about because they're concerned about the consequences of the proposal, we've noticed many, many, many unintended consequences, substantive changes in law. So, we're certain that proceeding with the rest of the reorganization would entail, a lot of staff time, but even for the things that we don't catch, a lot of unintended consequences.
Yeah, David.
So what I'm hearing is that there are two primary objections from the agency. One of them is unintended consequences, and the other one is usability. And that essentially boils down to anytime you make a change, we have to analyze that to make sure there are no unintended consequences. Big change, small change, anything in between, many changes, a single change. We have to analyze that. And that also applies to any reorganization or renumbering in terms of usability. If you change a lot of things, that means that you have many usability issues. If you change even one thing, that's a usability issue, and anything in between. And it seems like both of those things, or either of them individually, they boil down to do nothing, because anything you do will make this code harder for us to use, and anything you do can have unintended consequences. And we need to go away and have a think about that. And I suspect that that's what the offline conversation with Brian is going to be, which is if you do anything, that's going to cause us a lot of staff work, and it's going to cause our users a lot of problems. So please don't do anything. I suspect that's how that conversation is going to go. So what that boils down to for this commission, I think, is, okay, the agency is a stakeholder and they're a factor in this decision-making process, and their opinion has weight. But they're one factor in this process, and it's not necessarily outcome determinative. So we have one voice telling us do nothing, because doing anything will be hard. And so I think the question for this commission is, okay, taking that into account, what other factors should we be looking at in deciding whether or not we should move forward? And again, the agency's voice is important here, but they have a say, but we answer to the legislature.
Yeah, Kara.
So I'm not sure what the proposed change would be, but I mean, from my standpoint, the work that we do, I think, just trying to limit the changes to one small section, even though we can try as hard as we want to, there's likely going to be changes that impact other portions of the code that aren't, it's just inevitable. And I do fear that it's going to grow into a larger project than what we're anticipating. And, not just the work of our drafting attorneys trying to figure all this out, but also the people trying to interpret it and trying to figure out where did this go? And, I just feel like it could cause a lot of confusion for the public and people trying to utilize the code, doing it in this kind of piecemeal fashion.
Can I follow up on that?
Yeah.
Chair Simpson. Kara and folks with a little more experience in this than me, maybe you can answer this, but many of the examples that were listed in the memo and other examples that I'm familiar with involve renumbering or reordering or proposing amendments to whole schemes of the law, entire codes. Have we ever done something like this where it's a one-to-one analogy? There's a code that has an associated agency. So the penal code is used by every law enforcement agency in the state, but there's no one specific agency that is as closely tied to the penal code as Department of Fish and Game is to the Fish and Game code here. So have we ever done anything like this before?
Well, it was a couple of years before I started working in the legislature, but I believe it was 1976. We reorganized the education code, and it was like the whole thing. And that's the State Department of Education would be the primary, although it probably touched on UC and CSU and those folks as well.
Yeah. So
it was an enormous reorganization.
Brian has his hand up, so I'll call on him before I finish my thought.
Yeah, not the same scale. I think scale is kind of its own question, but we just finished work on specific pieces of the statutes that govern toxic wastes that are enforced by the Department of Toxic Substance Control. So we have an example of a small scale reorganization that affects a regulatory agency that's going to have to revise its regs to conform to the number changes. That's pending before the legislature right now. And they're not opposing. So at least with respect to a small bite piece, and by small, I still mean 2 pretty large chapters that we're going to work on. It's possible to do it even if there is a regulatory agency that's affected.
So where I was going with that was, again, trying to account for the status or position or relationship of the associated agency with the code. I'm not sure that's entitled to any special weight because we've done it before, so from that perspective, an associated agency is just another user of the code, just like anybody else. Lawyers, judges, hunters, fishermen, people who dispose of toxic waste, whoever. There's a body of people who have to rely on this body of law, and we reorganize and renumber or propose doing so all the time. And other groups of individuals and stakeholders and associated agencies have adapted to these changes just fine. And I'm struggling with why this one is so unusual or so specific or so special, or this group of stakeholders, will have some unique inability to adapt that we should carve this out and not subject it to the ordinary process. I mean, if the code needs reorganizing, we're here to propose reorganizations, and then the legislature makes an up or down call. They do whatever they do. So I'm not sure. And the last point I'll make before I saw that Xochitl had her hand up. Kara makes a valid point, which is that anytime you make a change, that can have snowball effects, and it's almost 6 in one, half a dozen another, whether you make one change or many changes. You change anything, you're in for a penny, in for a pound. So I'm wondering to what extent we should let stakeholder pushback hold up the process.
Commissioner Carrion.
My question is, we've just gotten kind of examples of different codes, the education code, different codes with different scopes of services that kind of dealt with these issues. I think this question is probably for Brian, is, in those studies, how did you address with some of the pitfalls and concerns that Attorney Dolan is mentioning? I've heard how the studies are different in a way, but are there any way that the commission has addressed these concerns that may be applicable and that we can utilize in this particular study?
Yes. We have sort of a standard suite of code provisions that are rules of construction that we use when we're doing a reorganization. They were included in this tentative recommendation. And the standard suite says essentially a provision of the reorganized provision, a renumbered provision shall be treated as a matter of law as if it were the prior provision. It's a continuation rather than a new provision. So there is express legislation saying that continuity is not an issue, and the former is the latter. And we also say that any reference to the former shall be treated as a reference to the latter as a matter of law. So a regulation, for example, that refers to a repealed provision is treated as if it refers to the successor provision as a matter of law. So there's no break in continuity of effect of any of the law. We also have the commission's comments, which are for decades treated as evidence of legislative intent, which declare that it's a non-substantive change. So again, as a matter of law, a strong argument that even if you could make an argument that the change has a substantive effect, the legislature didn't intend that it have such an effect. With respect to the fish and game proposal, we did something we hadn't done before because we were dealing with a regulatory agency for the first time as the principal user of the reorganized law. And we drafted and included a provision that created a sort of a streamlined process for making regulatory changes to conform to number changing. Within the Administrative Procedure Act rulemaking provisions, there's already an exception for technical provisions, technical changes. They go through a much simplified version of the normal Office of Administrative Law review and approval for regulatory changes. They're like regulatory changes without substantive effect or something like that. We included a provision that said, if all you're doing is changing the number to conform to the reorganization, that is a change without regulatory effect, and it can proceed under the streamlined process as a matter of law. And with respect to the regulations, I think part of what makes it onerous is that the regulations under the APA have to include, as part of the substance of a regulation, a citation to the provision that authorizes it. So you have to have a statement of authority. And so I think when Ms. Donlan said they had to amend 2000 regs to reflect the change that we made, I think that's because one of the provisions that we changed was sort of one of these foundational provisions that establishes the Fish and Game Commission's authority to adopt regulations. And so if you touch that, then every reg is going to have to be amended to change its authority citation. So it's not like you're necessarily needing to go in and parse the substantive content of the regulation to figure out how to conform it to the change. You just have to change its sort of provenance provisions. And that, yeah, that's a nuisance, but it's operationally pretty trivial to do that if that's the case. And in fact, in one of the earlier memos, when we discussed this issue before, this issue of like making conforming changes to regs, the staff even floated the idea of having our staff prepare an initial draft of the necessary regulation amendments, which we would then hand to the department, and they could review that draft to see whether it's correct, and then make any necessary changes and hand it on to OAL. So, you know, there are ways that the transitional costs can be mitigated. And we have tools in our toolkit that we use to do that, but there's limits to it. And that, you know, one of the reasons that in the memo, when I talked about the idea of doing sort of a test case on existing Division 2, one of the reasons that I talked about the different degrees of ambition is that if we did something like simply moving chapters as intact units without disturbing their content, then the only changes that are going to be made besides the individual section numbers is the numbers of the chapters and the application of any of the sort of meta provisions that govern the container into which we place them. Okay, so you got a division, and it says, for the purpose of this division, this rule applies, right? So if you pull a chapter out of that division, you've just broken that connection. And because it's no longer in the division, the rule that governs the division as a whole is no longer applicable. If you drop that chapter into a new division and it has rules that govern itself, then you have to worry about whether it's appropriate to have done that. If we move these chapters as intact units, that's the only thing we would have to worry about, is making sure that cross-references are corrected and the applicable meta rules for their containing structure are maintained without change. That's, for us, trivial. Okay, we do that all the time in reorganization. It's the simplest kind of thing. I am pretty confident that we could do that without introducing any scope for unintended consequences. And the other thing is, if that's all you've done, then when you have an implementing bill and it goes to its first committee, you can say, truthfully, that's all we did. And so, you know, there's no tinkering at the level of the language. There's no tinkering at the level of the section. It's just chapter relocation. And here we're going to show our work for how careful we were and that we did it correctly. And then they're satisfied, because really at that point, there's no scope for other problems if you constrain it in that way. And in my experience, if you can put bright line sort of boundaries on a proposal that are easily explained, it goes through the legislative process so much easier. You know, like Ms. Donlan was saying, that when they reviewed the 1,300-page proposal, there was just so much scope for unintended consequences. And I get that. Because we were making changes at the level of breaking sections up and moving the constituent pieces around, greatly multiplying the necessary carefulness and adjustment that needed to be made to make sure all the cross-references were still correct and all of the applicable meta rules were still applying where they ought to. And it was huge. And at that point, it makes sense that you would say, just the process of confirming that this is okay is more work than we think the benefit of this work will be. So, and I kind of think that's where they landed on this, was this is just too much for us to even vet. That's the main reason why I suggest the possibility of doing something narrower and perhaps less ambitious, like moving in intact chapters, so that there's a bright line boundary around the scope change that's easily explained and greatly minimizes the number of potential issues that have to be assessed.
Brian, could I ask that our general counsel, Wendy, be allowed to weigh in a little bit?
It's up to the
Oh,
chair.
Commissioner Carrillo, I think had something or somebody
Oh,
raised their hand.
Thank you.
First.
I am interested in what the general counsel plans to say, but I was thinking that I'm feeling agreement with what Brian was just articulating, proceeding with the narrow proposal. But I'll withhold further comment for now.
Sure. Okay. Is it Wendy?
Sure is. Am I muted?
No,
Okay,
we hear
thanks,
you.
Brian. Thank you, Chair. I want to acknowledge that this is difficult. We, as we have tried throughout to emphasize, we really appreciate your staff's time and your effort. And I hope that that appreciation manifests not just through our words at these meetings, but by the thousands of hours that we have dedicated towards this review, the thousands of hours by dozens of staff that has resulted in, as Angela has said, significant changes to the code, and also has resulted in identifying numerous instances in which your very adept staff, who were doing their absolute best, proposed changes or flag things that were going to result in substantive changes. And that's with all due respect and just acknowledging what Brian was just remarking upon, that it's very difficult when you're moving things around in such a dynamic way to not inadvertently move a comma and have a substantive change. Chair Simpson, we provided some detailed examples of those inadvertent substantive changes in a variety of communications. And if you'd like to dedicate some time, we can go over them in specifics. With that in mind, it is really concerning to me, and I hope that there's no takeaway from this, or no impression that the department's concerns are a result of general aversion to change, or that what we're concerned about is trivial or a nuisance. That is not the genesis of our concerns. Our concerns are that we're spending thousands of hours, and what we're finding is that just inadvertently, with all of the best lawyering there is, there are these inadvertent substantive changes. On top of that, there are other, I think I heard the term transaction costs, which we have noted. But confusion and error, which was what was in the director's letter, is what we're principally concerned about, driven by substantive inadvertent changes. I have sat in many of these meetings now over the years because we have really wanted to honor your process. So in addition to engaging through the hours of time offline, we've been engaging in these meetings. And I have noticed that a lot of times you remark that you put things out to the subject departments and you don't hear back. We have really tried to honor your work by providing input. And I hope, Vice Chair Carrillo, that the impression that's left from this meeting is not that the input from the subject matter department is exactly precisely the same as all other stakeholders. And again, I think a reason why it might be differentiated is because we have put in thousands of hours engaging with your staff on these changes. And I'm not sure that other entities necessarily have. So even setting aside our position as the subject matter expert by the legislature, just the amount of time that we put in might cause our input to be worthy of particular consideration. And again, I hope that it's the case that that's given some recognition. We really appreciate, and Angela did, I think, emphasize this, the concepts that not just Brian, I shouldn't say Brian, that the memo offered up. We have found in the past that there are unintended consequences with this process. And so it seems worthy of us to deliberate also on a pivot from the position represented by our director. And we need to circle internally on that. That's not just kicking the can down the field. That's just being deliberative and honoring this process. And that was the basis for our request that we provide that Brian's proposals, the memo's proposals, some additional consideration before looping back to provide input. And that includes the fact that, you know, in their presentation of those more discrete options, what I heard today was that those might be an opportunity to not to pursue additional incremental change down the line. And I think it would behoove all of us to have some idea of what the sideboards are on that those incremental changes if we were to pursue them, if we were to shift gears and pursue that. I think that there's a lot that needs to be talked about before moving to that approach. So that is the reason why we were suggesting that there be some time for us to circle internally to provide input on that more discrete approach. And I just want to emphasize that it wasn't merely, you know, and not that Chair Simpson, you were suggesting that we were kicking the can just for sake of kicking the can, but because this work is so very resource consuming and there is so much at stake, we want to be really thoughtful about it. So just in closing, I just want to emphasize that there is nothing trivial about this for us. It is, and it is not a matter of just general aversion to change. And that what you're hearing from us and the intensity of our concern is in part our honoring of the work that you're doing and our appreciation for it. Because there has been so much accomplished so far, and the work can be, extremely impactful. And we want to make sure that those impacts are done in a fully intentional way. Thank you.
Thank you. Okay, Brian or
Victor has his hand up.
Commissioner King has his hand up.
Oh, I'm sorry. Yeah, Victor.
Yeah, I appreciate all these comments, but having worked in government for 19, 20 years, I think that anytime you don't have a hard deadline, the can will always get kicked. It'll get kicked forever. And I'm not saying that anyone's misrepresenting anything. We can all have the good intention that the can will not be kicked forever, but the can always gets kicked forever unless you have hard deadlines. So I appreciate the need to go slowly and to be careful. I would feel more comfortable if we actually had some hard targets, because at some point we need to move on. And if I don't see an actual date, I have to assume, I'm not calling anyone a liar, but I just know how government works. The can will just keep getting kicked and kicked and kicked. And the way work allocations work is that we make it a priority when there are deadlines looming. And so I'm all for giving the department time to digest and to flag really important things. But I need, just speaking for myself, I need to see a hard deadline, a really hard deadline in which we can then move forward. Because if there isn't one, literally nothing will get done. And this 1,300 pages is going to sit on a shelf.
Yeah, Brian, okay, how about Commissioner Jenkins first?
I agree with that. I think, if there's any way, would the commission, would staff, or would we come up with some type of proposed plan for doing these incremental changes so that we could, my fear is that we do one small change and then the rest doesn't happen, so is there any way we can come up with a kind of a overarching plan for how these smaller changes would take place, or how does that work?
Brian?
A couple things. One is that I'm certainly happy to have further conversations with staff from the department between the meetings, but I don't see a problem with preparing a more concrete proposal for the next meeting that could either be just a catalog of where chapters would go, or even a draft of the chapters having been moved where I propose that they go. And I don't think that would be wasted effort, even if the result of the conversations with department staff is that they're leery of it. I think it would be worth having a tangible expression of the concept so that people could speak concretely rather than more generally about concerns about possible inadvertent change. As for a long-term plan, I guess our general practice is that we reevaluate the next year's work each year, sort of in October, November, December. One of those meetings, we decide what we're going to do for the next year. My thinking on this is that I'd kind of like to put a toe in the water before committing to a multi-year course of action. I'd like to try the concept and see if it succeeds. And if it doesn't produce good results, then my recommendation would be that we gave it a shot, it didn't work, put it on the shelf. But if it does work, if it looks like a successful approach, then yes, at that stage, I think it would be worth maybe giving some thought to other good candidates for similar incremental efforts, and we could lay out, if the commission wanted to see it, a longer term proposed plan. But my overall sense of this approach is that it would be a long-term multi-year effort at sort of a low-grade continuous study to find and process good candidates for this kind of reorganization until we're out of good candidates. I can't predict off the top of my head how long that would take. And I really don't know whether this would be successful. I heard in General Counsel Bogdan's remarks a couple of things that I think were echoing things that I said. And I want to clear things up a little bit. When I used the word trivial, I wasn't talking about the concerns that the department has. I was talking about the degree of difficulty that I would face if I were to put together a draft of the type that I've described, like a medium ambitious Division 2 proposal. I think that it would be trivial for me to achieve a good result. The thing about general aversion to change, I probably shouldn't have said that in the memo. I think it's too glib. I think it's more that when you take on a big reorganization, like I said, it's hard for people to even reach a comfort level. And I think that proved to be impossible for the code-wide reorganization. It's impossible for people to have a comfort level that it's okay, or even that they can find all the things that need to be fixed. It brings to mind an experience we had with a smaller scale reorganization some years ago, where we reorganized the mechanics lien law. And there was no single agency that dealt with that, but every general contractor and subcontractor and every building trade, every material provider in the state relies on the mechanics lien law. And we did our best to bring them to the table, to include them in our process. we got a bill introduced, and then they showed up and they did a letter writing campaign, and they were all opposed. And I think to some extent they didn't want to learn new numbers, but to some extent I think they just weren't sure that we had done it right. And so their position was, legislature, we can't trust that this is okay for us. We're worried it's going to cause problems. You shouldn't do it. What happened instead was that the Senate Judiciary Committee required them to all come into a room with us and tell us exactly what problems they had with it. And then we would fix them. And that's what happened. We spent weeks in meetings, me and Steve, listening to these representatives of the different trade groups tell us, well, we don't like this, well, we don't like that. And we fixed their whole punch list, and the bill got enacted. That is possible if you're operating on a relatively small scale. You can actually work through things in concrete, specific terms, rather than generally having a concern that there's too much here to even analyze. And I think that's the problem that we have with the proposed code. So I guess my pitch would be, I'm happy to talk to the department, but I think I would like to take a shot at giving you something at the next meeting that puts words on paper so that you can see more concretely what I'm talking about. It might not be the entirety of Division 2. It might not be a draft language specifically. It might just be a plan. But I don't think we should stop that process just because the department wants to talk more with me about their thoughts on this.
Commissioner Carrillo.
I think I'd like to move the proposed plan that Brian just articulated of following his, it's described in the memo under the heading possible alternative approach, which is his series of narrower recodification proposals. And part of my motion is that I'd like to see the first in that series at the next meeting. And Brian, you know, at your discretion, where you proceed division by division or article by article, and you know, you don't have to go in numerical order. You know, pick the best one or the worst one, or you know, whatever makes the most sense to you. So my motion is in two parts. One is to proceed with Brian's possible alternative approach, and yes, Brian.
Could you please address whether or not I should tinker within the confines of a chapter or move chapters as intact units? And my recommendation would be the latter, at least at this stage, because I think it would greatly reduce the scope of concern about unintended effects.
Then I will so amend my motion, and then the second part of my motion is that hopefully we can see that in written form at our next meeting. And then I'd offer a thought before I cede the floor, which is that in the meetings and conversations that I'm sure you're going to have, Brian, with the department staff, like Victor, I've spent a lot of time in and out of government, and in my experience is similar to Victor's. On a different but related respect, which is it's a lot easier to shoot down an idea than to come up with an idea. So in your conversations with various stakeholders, whoever it happens to be, I would suggest that you challenge them to come up with their own idea, an alternative, a positive proposal, rather than just trying to shoot down whatever proposals you have on the table. It's a lot easier to say no to things than it is to come up with your own idea. And so if they want to shoot down our idea, these stakeholders that you talk with, let them come up with their own proposal, and then we can talk about that.
And can I add to that? I would also begin with areas of agreement where there is no contention, no issue, because that often provides the positive momentum you need to address the more meaty issues.
Totally agree.
And I would like to concur with David and Anna, I guess. And my sense is I'd like to see, with an example that Brian feels is appropriate in this context, of the benefit versus the cost. I'm still sort of in the ether here about the benefit of the reorganization, about what, okay, your example, when you look in the, Department of Fish and Game, whatever, Fish and Wildlife, whatever it is, you thought that's going to be sort of the structural of the organization and the powers and yada, yada, yada. And there's all the independent, the policy stuff in there. I would be interested to see tangibly what a reorganization looks like and get some better sense of what the benefit is. I mean, I have written probably hundreds of code sections that are in the education code scattered throughout. Some are little, some are big, some are right. And so I got a sense of how codes can get all mixed up and stuff can be, end up, it happenstance just in the wrong place, and trying to find stuff can be a problem. So I think this sort of let's take a shot at what this kind of contained reorganization might look like, so we can all get a better sense of if the reorganization is a solution, what's the problem, and see what it is that the cost versus the benefits versus the potential costs of it might be. So I'm for it. Any
One last comment I would like to add is, has the Legislative Analyst's Office ever done a budget or other type of analysis about this department, and any recommendations that they've had? Just curious to do that research.
Well, they might be able to answer better than me. Not speaking to their budget, but the legislature did mandate several years ago the strategic vision review process that the resources agency conducted, which was the genesis of this commission project. And one of the recommendations from the resources agency was that the code be cleaned up. And that was then translated into a request from committee chairs to the commission, and then the resolution that continues in effect that directs us to recommend changes to improve the organization of the code. So, certainly at some point there was a recognition that there's a problem with the organization of the code.
Yeah. Kara, did you start to say something?
I just wanted to say I do support, doing some type of examples that we can look at and evaluate. But I still have the concern that, even if the legislature did approve this kind of smaller incremental change without having some type of plan for how we would move forward, even, at the outset, I just feel like it's almost necessary to do so with, and kind of having a broader outline of what we want to do versus just kind of, okay, just take this small portion that we know is going to work and put it through. I mean, I know it's still probably beneficial in terms of meeting the goal of trying to streamline and make the code clearer, but in my opinion, I still feel like it would be in our interest to kind of look at other, just the code as a whole and see where the other opportunities are that we can improve the code as well.
David.
So Brian, I don't know how feasible this is to do it by our next meeting, but maybe one way to incorporate Kara's point, which I agree is valid, is to give us an example. This is the first one that I've picked, and here's what I would do with it, and here's the order in which I would go with the other things. So if you're going division by division, I'd start with division 3, and then I'd do 4, 5, 6, and then 1 and 2, or a schedule or a plan, an outline of the to-do list, basically.
Yeah. I don't know how feasible that would be. I mean, I think there's a fair amount of thinking that's required to see where the problems are most acute. And it's my inclination to pick the low-hanging fruit first, but I don't know where that is yet. And I don't think, I understand what you're, I guess I'll differ from Commissioner King in one regard, which is that the commission does not kick cans down the road, even if we don't have deadlines. We make progress on studies and we set realistic schedules and we get the work done, even when we don't have deadlines. And so while I understand your concern, Commissioner Jenkins, that this first step might be the last step when it ought not to be, that's in your hands. If the decision is we're going to try this to see whether it is practicable, whether we can get it done and get it enacted before we commit to doing more of it, the next step would be I would put a memo on saying, okay, this worked. What's next? And I would not drop that until the commission decided we've had enough. So I can assure you that within our own internal process, we would be the ones who would control whether the can gets kicked or put on a shelf or whatever metaphor you want. So I'm not too worried about the first step being the last step just through institutional inertia.
I appreciate that remark, Brian. I wasn't actually directing the kick the can towards staff or our commission. I think I was obviously reflecting my concern that what I was hearing from the department was extremely open-ended. And again, I'm not in any way saying they were intentionally misrepresenting that they don't want to kick the can down, but I didn't hear a real desire to wrap this up either. I mean, in all honesty, and we need, and it's good to know, and you did just remind us that it does get wrapped up because you are kind of, in a way, driving that whip. So maybe you've answered my concern and question. I just want to make sure that we were driving this and not just all deciding, oh, this is very complicated and we just need to think about it some more, and to have that same discussion a year and a half from now. This is still very complicated and we need to think about some more. But you're right, you reminded me that you do drive the whip. So so thank you for that.
I see two hands up. Ms. Bogdan or Donlin?
Go ahead, Wendy.
Yeah, so I feel very lucky. I can reassure you, you're in a good position, that you're not dealing with a department that either kicks the can down the line or just shoots things down without proposing alternative, positive, constructive options. And I think Brian can vouch for the fact that over the years that we've been working on this, again and again and again, where we've spotted problems with proposed language or approaches, we've provided alternative suggestions and really tried to meet this this effort halfway, more than halfway. So that's a reason why we continue to carve out the time and the resources to come and speak to you, because we do want to work constructively. So again, that's something that you don't have to worry about, is that you're working with an entity that just says no. And again, we're looking right now at the largest revision to the Fish and Game Code since the 1950s.
Okay. I appreciate that. Thank you. Yes.
Just in terms of the representation of kicking the can down, again, I just want to reassure you that that's not something that is our pattern and practice throughout this, although I realize that we've taken longer than you initially would have, your schedule initially would have anticipated. I think we've been clear, although, we haven't always had a meeting of the minds about the pace of these changes. It's been our experience that the thousands of staff hour necessary to review and respond has necessarily caused a different pace of review than I think that sometimes the schedule has initially anticipated. We have come through, and I think Steve can vouch for the number of meetings that our staff have been in over the last many years, but even just in the last few months, providing input and constructive suggestions to try to bring this to closure. So again, I just want to make sure we're all really clear here. This is not a situation in which you have a department that's trying to just endlessly defer or not or being obstinate. With that in mind, if my suggestion that we're looking to consider this pivot more before coming back, if there needs to be some clearer bookends on that, if I wasn't clear in my bookends, I'd be happy to make a commitment to come back at the next meeting. I'm happy to put sideboards on that. It wasn't my intention to suggest that we're looking for an open-ended, calendaring date to circle back to the group. Thank you.
Okay, thank you for the clarification. Much appreciated. Thank you. And Commissioner Carrion had her hand up?
Yeah, yes, I wanted just to express my gratitude to both attorneys Donlin and Bogdan for their commitment to working on these issues and the partnership that we are developing with the agencies to ensure that we take into considerations the practical concerns and the valid issues that you are pointing out. And I think that we have, I actually, when my first appointment was working on this initial fishing game code a long time ago. And it's great to see the amazing amount of progress that has been done by the commission. And I believe as a commission member, I recognize that has done in part because of your contribution. So thank you for coming here and thank you for working on, with us on that.
Yep, you're here. Okay, there was a motion with an amendment by Commissioner Carrillo. Is there a second?
Second.
Been seconded. Brian, call the roll.
Commissioner Carrillo,
Aye.
Commissioner Carrion,
Aye.
Commissioner Cubas,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
Commissioner Simpson.
Aye.
That's all I need on that memo, but this general topic also has the memos that Steve's going to.
Right. Steve, you're on.
All right, thank you. Good morning, everyone. This should be
Just
much,
barely. Morning.
this should be much more brief. As in most of our meetings the past year, we have 2 recurring memos for your consideration. At this meeting, we also have a supplement to the first memo. That first memo is Memorandum 2022-22, which presents and analyzes more proposed revision that we have received public comment on from the Department of Fish and Wildlife and the Fish and Game Commission. Again, the memo categorizes the proposed revisions according to the nature of the public comment received, and then each category of revisions is followed by a staff recommendation as to how those revisions as a whole should be treated. And then the second memo at 22-23, that's just an informational memo. We don't really need to talk much about that, although I'll ask if anyone has any questions in a little bit. That just typically presents in an exhibit any of the latest revisions that we've added to a draft recommendation. So turning to the first memo, 2022-22, and its supplement. Each category, once again, has been presented as a consent item. And the commission has found it efficient in the past to simply ask if any commissioner has any objection to any of the staff recommendations in the entire memo, or any questions or comments. And if there are not, then we can have a motion to approve all of them, but I'm happy to hear questions, et cetera.
I do have one question. It's not one of my stupid snarky comments this time.
Go.
On page 8, section 3407, you're changing a cross-reference to the Title 14 of the California Code of Regulations. So my question is, when you say deer tag should be countersigned by a person who's authorized to countersign pursuant to this code regulation, is that an intent to have the statute define the nature of the person who's permitted to countersign, or is that an attempt to, or is that intended to say regulations decide you have to countersign it, but the regulations define who's eligible to do that? Because if it's the former, if it's statute is attempting to say, and the person who is authorized is defining who's authorized, you need to put a date by the code section as it read on, and that has the law then define the nature of the people who are eligible to countersign. If it's the latter, if it's intended to be simply say that you have to be countersigned and the regulatory process defines who's eligible to do that, then I would suggest you take out the code section, the section. You simply say the persons who are authorized by regulations, or by Title 14 of the regulations or something, rather than having a specific, because that would have the effect of doing exactly what people are concerned about us doing on statute, because then that would if the regulatory process entity, which is the department, is rearranging its regulations and changing the sections of regulation, we'd have to come back and amend statute every time they change the number or right?
Yes.
Making sense?
I believe I understand what you're asking. Actually, it's an example of a number of potential issues with various code sections where it could be interpreted in one of two different ways and
Right.
with different effect. In this particular case, the section in the CCR, the regulations, was no longer exists. And I don't know what the history was, but this was as of when we did the tentative recommendation, it didn't exist. And so we asked, and both agencies indicated that the correct regulation should be the number that we indicated here in the revision. We did not address the issue that you're talking about in terms of the phrasing of the section or the provision in the section. I think that it would probably be wise for us to take this out of this first category, which is a category in which we're just asking you to approve the revision, and put it in a category in which I could speak to staff counsel with Department of Fish and Wildlife. And perhaps there is a revision that would make this language clearer and address the issue that you're talking about.
Okay, yeah, because it wasn't clear to me whether, because like when I write parts of the Constitution, I want to say, this is school district as defined by this code section as it read on XYZ date, so that's the Constitution is defining the nature of whatever it is.
I think I understand the issue you're raising. I guess I would say that in a number of these provisions that we've been looking at, we have only been addressing very specific problems, such as an incorrect number.
Got it.
And there is a sense, and perhaps either Ms. Donlin or Ms. Bogdan might agree that there is a sense that when a provision has been on the books for a long enough period of time, it is generally understood as having a certain meaning. And so it's not necessarily a problem, but I agree that it could be clearer. And if it is clear, one interpretation is meant to be the interpretation, then perhaps we can slightly rephrase the language to address that point.
Okay, so we take that one off the consent list?
Yes, that would be, well, yes, I will include that in my request for a motion. Any other objections or questions or comments on anything in this memo or the first supplement to the memo?
Hearing none?
Okay.
Seeing none? Is there a motion to approve? So you'd be looking for us to approve the whole memo, or
all staff recommendations in memorandum 22-22 and its first supplement, with the exception of the section 3407 being taken out and put in what we've labeled the fourth category, which is further input needed.
Right.
I'll move the memo.
Second.
And it's been moved and seconded. Okay, Steve, want to call the roll?
Yes. Commissioner Carrillo.
Aye.
Commissioner Carrion.
Aye.
And hi, by the way. Commissioner Kuas.
Aye.
Commissioner Jenkins.
Aye.
Commissioner King. And that sounded like an aye. And Commissioner Simpson.
Aye.
Okay, so that is 2222 and its first supplement. 2223 is an informational memo. Often it has an exhibit attached to it, which is the most current version of the provisions that have made its way all the way through this process. We don't have an exhibit because there aren't any new additions, but I have recently received correspondence from Ms. Donlin, and there will be, definitely will be more at the next meeting. And also, as indicated at the end of that memo, we have now presented to the commission, at least initially, all the proposed comment on the proposed revisions in the tentative recommendation that the commission has said they want to consider in this phase of this study, in phase 1.
Okay.
So going forward, the first memo will be about trying to resolve issues that still remain, such as the issue that Commissioner Simpson just raised.
Okay.
But there's no decisions called for in that memorandum. Anybody have any questions or
Questions, comments from any
Okay.
members?
All right.
Hearing none, seeing none.
Thank you.
Okay, I think that concludes the agenda. Brian, anything else?
You in May, remember the April
May.
meeting. Cancel.
Yes, so we won't be meeting again in April, then in whenever it is in May.
Okay.
We will see all of you again. With that, the commission meeting will be adjourned.
Thank you.
Thank you, everybody.
Good
Bye,
meeting.
everyone.
And thank you, department, as well.